Welcome back to this final part of this four-part session for law sessions in relation to contract law, and in particular what is involved in the contents of a contract. Now, we started off with terms in the first segment, and we are now concluding with the implied terms, and certainly we will end on particular remedies. However, in the last session we flagged up 4 implied terms which were implied by statute, section 12, section 13, section 14, and section 15, some important sections from the Sale of Goods Act. And the point I made earlier was that in the last segment was that we would consider these in a little bit more depth in this session. Now let's start with section 12. Section 12 applies to all contracts for the sale of goods, so it will cover private sales in addition to where goods have been purchased from a shop or other business. Now, section 12.1 implies a term that the seller has the right to sell the goods. Now, this covers situations where the seller is selling stolen goods, for example, whether the actual thief or a subsequent sale in the chain. This term is a condition in all sales. If you end up going on after contract to say do commercial law, this will take on a little bit more significance for you, because in the context of commercial contracts, of course, we see where you have a situation or a phrase certainly in contract law that says you cannot give a better title than you have. So even though you're warranting that you have good title, the fact is that somebody with a better title can certainly trump you. So the first condition is that if you're selling goods, that it is a condition of the sale that you have good title. Case in point, Rowland and Duval. It's a 1923 case, and there the claimant was a car dealer. He bought a car from the defendant for £334 and painted the car, put it in his showroom, and then he sold it to a customer for £400. Now, 2 months later, the car was impounded by the police because they said it had been stolen. It was then returned to the original owner. Now, the claimant and the defendant were unaware that the car had been stolen. The claimant returned the £400 to the customer and brought a claim against the defendants under the Sale of Goods Act. The court held that the defendant did not have the right to sell the goods as he did not obtain good title from the thief. Ownership remained with the original owner. The defendant had 2 months' use of the car, which he did not have to pay for, and the claimant was not entitled to any compensation for the work carried out on the car. Now, section 12.2a implies a term that the goods are free from any undisclosed charge or encumbrance. Now, this applies where, for example, goods which are still subject to hire purchase terms have been sold without telling the purchase of the hire purchase agreement, or whether any other debt has been secured on the goods. Now, let me just make a point here as well, that when we talk about hire purchase agreements, I know that if you are in a jurisdiction where, for example, a car can have a lien on it, and certainly this happens in the US, it happens in some Caribbean countries where a car is secured borrowing. Well, in the UK, a car is not secured borrowing. Even if it is on a hire purchase agreement, the fact of the matter is that the person who has the car is the owner. It is not the bank or whoever the lender is. So the person who has the car can legitimately sell the car on to somebody else, even though there's a hire purchase agreement in place, because, as I said, in England it is not secured borrowing. That is important because sometimes persons may inadvertently, in the law exam, for example, if they're doing an external degree, make some reference to that. I just wanted to say to you, I would rather you not make a reference to that, because it is not that type of borrowing here. Now, such a term, of course, is only a warranty. So whilst the purchaser can claim for any loss caused by the charge or the encumbrance, they cannot end the contract. Now, section 12.2b implies a term that the purchaser will enjoy quiet possession of the goods. And this basically acts as an ongoing assurance that no one will interfere with the buyer's right to possess or use the goods. And that also, section 12.2b is also a warranty. It's not a condition. Now, section 13, sale by description. Section 13 says that where there is a contract for the sale of goods by description, there is an implied term that the goods will correspond with the description. Now, this section applies where the sale is solely by description. If the buyer sees the actual goods before the sale, then section 13 cannot be relied upon. It's interesting because if you get a law exam, for example, which is an exam question to do with maybe purchasing on the internet, for argument's sake, arguably, all internet purchases are sale by description, and it is a condition. Now, if you were to consider that for a minute, it is saying that what you see should be what you get. That's section 13. Now, there is some overlap when we get to section 14. There is some overlap between section 13 and section 14, because what may very well be described may very well not be fit for the purpose that you wish to use it for. But that's another matter when we get to section 14. But the point now is that once something is described, then you are expecting that the description will fit the goods when you get it. Now, in Harlington, Leinster, and Christopher Hull Fine Arts in 1991, the claimant purchased a painting from the defendant. Now, the cost of the painting was £6,000. The painting was described in the auction catalogue as being by the German Impressionist artist Gabriel Monta. Both the buyers and the sellers were London art dealers. The sellers were not experts on German paintings, whilst the buyers specialized in German paintings. The purchasers sent their experts to inspect the painting before agreeing to the purchase. After the sale, the buyers discovered that the painting was a fake and was worth less than £100. That's why I'm always worried about experts. Well, they brought an action based on Section 13 Sale of Goods Act, in that the painting was not as described. The court said that by sending their experts to inspect the painting, then this of course meant the sale was no longer by description. Section 13 only applies to goods which are sold by description, and therefore the buyers had no protection. Section 13 is simply concerned with description and not quality, and that was also made clear in a subsequent case of Arcus and Renaissance, which is 1933. The point I want to flag up though is this: just description does not mean, let's say, the text. If it is that the thing has been described, but you have had opportunity to inspect, and you so inspected, then it certainly can't be a sale by description, because description is where somebody is just telling you about something and that's it. And therefore, you either see it in a picture or something and then you get it. But be careful. Second case, as I said, is Arcus and Renaissance in 1933. It's a House of Lords case. Now, a contract for the sale of a quantity of wooden staves for making barrels described the staves as being half-inch thick. Some of the staves which were delivered were not half-inch thick though, but very slightly out. There was nothing wrong with the quality of the wood, and they could still be used for the intended purpose, which was to make barrels. The buyer, though, rejected the goods as the price of wood had fallen and he could purchase them cheaper elsewhere. Now, it doesn't matter what his motive or reason was. It's irrelevant. Because Section 13 is a condition, you can just treat yourself as discharged from the contract. The court said that the purchasers were entitled to reject the goods under Section 13 as they were not as described. It said half-inch, it's not. But when you look at this case, please be careful, because you have to take on board the position in relation to non-consumer sales, because that has since changed. Section 13 is not automatically a condition in non-consumer sales. Okay, just consumer sales. Another case of Raymore and Lauder, 1921, contract for the sale of 3,100 tins of peaches, described the tins as being packed in cases of 30. When they arrived, the tins were packed in cases of 24. Now, they were still there, But although the agreed overall number of tins was supplied, the court said the purchaser was entitled to reject the goods as they were not as described. And the term implied by Section 13 is, as I say, a condition. That's the reason. Again, be careful of non-consumer sales because it is not automatically so, and you can actually exclude them in a non-consumer sale, but you cannot exclude them in a consumer sale because they are conditions implied by statute. Now, when as I was saying, the term implied by Section 13 is a condition in relation to consumer sales, but an innominate term in relation to non-consumer sales. And what that means is that you have to look to its effect. Now, moving on to Section 14, this is an implied term as to quality. Section 14 only applies where the seller sells goods in the course of a business. A lot of times, contract law questions will ask you what is described as the sting in the tail type question, which is where the examiner gives you a question and at the end he will say, would your answer differ if Tom was selling her car in the course of a business? And this is where you would be expected to take on board a Section 14 discussion. Now, whenever you see those sting in the tail type questions, it does mean that you have to treat that part of it almost like a part B of the question. So you have to deal with it in somewhat similar depth or just sufficient to make sure that you don't go out of time. Now, it therefore does not apply to private sales because it is as on the one side a business. So it does not apply to private sales, although there may be an action for breach of an express term or misrep if you're looking at a private sales scenario. The question of whether goods were sold in the course of a business was considered in the case of Stevenson and Rogers in 1999. An interesting case, and again, please be careful because the examiner does use this. The defendant was a fisherman. He sold his fishing boat to the claimant. The claimant brought an action against the defendant based on breach of Section 14 of the Sale of Goods Act as the boat was not of satisfactory quality. Now, Section 14 applies to the sale of goods sold in the course of a business. The defendant argued, which seemed fairly logical at the time, he argued that the sale of the boat was not in the course of his business. He said his business was catching fish and selling fish. He said he was not in the business of buying and selling fishing boats. And this raises an important point because when they say in the course of a business, are they saying in the course of your business? Or are they saying as long as you are a business person and you do something, anything in the course of that business? Well, it appears to be the latter. So if I am running a school, for example, and my business is teaching, but I have chairs, apparently, based on this case, if it is that I sell a chair from the school and it is not of satisfactory quality, I could be held liable under Section 14. The court said that the sale was in the course of a business and therefore the defendant did have to ensure that the boat was of satisfactory quality. Now, liability under Section 14 is strict and it doesn't depend on proof of fault on the part of the seller at all. Now, there are certain parts of Section 14 which I'll not necessarily go to in depth, but I will certainly say to you that you need to consider, because Section 14.2 considers the fact that you're looking at goods sold in the course of a business. There's the new 2A, which says for the purposes of this act, goods are of satisfactory quality if they meet the standard that a reasonable person would regard as satisfactory, taking account of any description of the goods, the price, and all the other relevant circumstances. Because if I'm selling you a second-hand car, it is certainly not going to be of the type and kind of a new car, for example. Section 14.2b, for the purposes of the Act, the quality of goods includes their state and condition and certain other factors such as the fitness for the purpose, the appearance and finish, the freedom from minor defects, safety, durability, All of these are considered. And when you apply this section, a judge would therefore consider whether a reasonable person would regard the goods as being of satisfactory quality, looking at all those conditions or all those issues that I raised earlier. So again, if you buy something that is new versus something that is used, then the courts may take a different view completely, because of course it makes sense. Now, sale by sample, of course, is where it says if you're buying something by sample, then it should be that the bulk matches the sample. If there is when you're looking at section 13, which looks at description, point to make here is that all sales by sample will also, of course, be a sale by description. It just makes sense, because it means that you are waiting for the bulk, and if the bulk does not correspond, then of course you can treat yourself as discharged from the contract. Now, the Supply of Goods and Services Act does imply certain terms into a contract, and it is one that I would suggest that you have a look at, because it does actually provide some protection for consumers. There seem to be quite a fair bit of overlap nonetheless with the Sale of Goods Act, but I would suggest that there are certain sections which are fairly they go some way to adding something to the Sale of Goods Act. Now, Section 2 to 5, for example, replicate the provisions of the Sale of Goods Act in respect of Sections 12 to 15. Section 5A provides that in non-consumer sales, the terms implied by Sections 2 to 5 are inanimate terms. Section 6 defines a contract for the hire of goods, for example. And again, there's some duplication in respect of Sections 7 to 10. And the idea then is, when you look at this section, you also look at the supply of services, and it does define, for example, a contract for services. It does consider terms where the supplier acts in the course of a business also, and the Section 14 there further looks into situations where the service is carried out in the course of a business, and Section 15 of the Sale of Goods and Supply of Services Act looks at where a service is carried out and no price has been agreed. Overall, therefore, that is more or less where the contents of a contract and the terms contained therein that I feel that you should have an idea about are included in this session. Now, that ends this session, and certainly we will no doubt move on to another session, and hopefully you will join us in that regard.